Good morning. On behalf of Judges Maldonado and Wallace, welcome to our second day of hearing cases here in Detroit. I know that we have folks that are very experienced in appellate work. You know your time. You know that we've read your cases. We're familiar with the facts. I'd encourage everyone to identify those one or two those issues that your case turns on and focus on those. So with that, why don't we go directly to the first case? That's item number 14. But before doing so, I would also remind you, if your case involves any minor children, please do not identify them by name because these proceedings are being recorded. So with that, I will call the first case, Schreiber versus Consumer Energy Corporation. It's item number 14, 376788. Morning.
Good morning.
No, none of you recognize me because I'm not a regular in this court. I went to a seminar a few weeks ago and Chris Desmond was saying, if you spend more than 30 seconds introducing yourself to the court, you've gone too long. So all I'm going to say is that, and this is just it's not that it wasn't said, it's just said differently. As a notice pleading state in Michigan, the complaint must contain a direct statement of facts on which the pleader relies in stating his cause of action, only with specific allegations reasonably necessary to inform the adverse party of the nature of the claims the adverse party has to defend. It is not a presentation of evidence, and that distinction is fundamental. Facts are the underlying events and circumstances that the pleader asserts occurred. Evidence is the proof of those facts, which is a matter for discovery and trial. I'm a much better writer, I think, than an arguer, so I will rely on my brief at this point and answer any questions, try to answer any questions that you may have.
I have a question. So we can agree that if your client had submitted a property protection insurance claim within a year of this incident, regardless of fault, the insurance carrier for the defendant would have been required to pay all the damages, right?
Yes.
Well, why didn't they do that?
I couldn't answer that.
That's a good answer.
I was not the attorney. What I do, the little bit I knew about it is the attorney tried to resolve the case quickly, and as soon as he couldn't, he said, get another lawyer. And my client just happened to read about a case that I tried, a trespass case, and one of my few successful cases, and called me. And there's, as you can tell, there's very limited damages in this case, but I thought I would take it because I had an interest in it.
Understood. Thank you. Okay. Any other questions? No. Okay. Thank you very much.
Thank you.
Good morning, Your Honors. Matthew Nichols appearing on behalf of the defendant appellee consumers. Judge Wallace, with respect to your question, I think the answer is, had the claim been submitted within the 1 year statute of limitations period under 3135, we would not be here.
I mean, under 3121.
Right, 3121. We would not be here, at least in this capacity. Maybe a dispute would arise as to what the extent of the damages were, but
Well, then the question would have been, if he had actually submitted it, I guess one of the defenses would have been it was intentional. It's not an accident, so it's not covered under the PPI statute.
sure, they could still make that intentional argument. I think that's really central issue with this property damage case, is intent. With respect to my colleague's arguments, I think he focuses too narrowly on C8 rather than on acknowledging the C7 standards, which I think the trial court's ruling fits within. Of course, under C7, court can construe documents and evidence outside of the pleadings. Of course, if the motion is brought only on the pleadings itself, I think, the C8 rules still apply, except all well-pled allegations is true. But when the motion for summary introduces evidence outside of the pleadings, the trial court is required to consider that. And in meeting the burden of, as the moving party, the burden shifts here to the plaintiff to come forth with clear and decisive evidence to negate the bar under the statute of limitations period under 3145, which is 1 year. Here, I think the trial court got it right. We look to plaintiff's response to the motion for summary disposition, but there was no evidence that was submitted. I believe in the motion for recon, they submitted an affidavit with pictures of the property, and I think there was an affidavit from an arborist. But really what those pictures only show is what's not being disputed. They show the damaged trees, which consumers does not dispute that some of those trees on plaintiff's property were damaged. They don't show anything else. Most of those photos were taken, I think, it's kind of important. The photos that plaintiff relies on were all taken during the day. I think they show a different depiction of the property than what it looked like at the time of the accident or the incident.
How could
That was,
how could all those trees being run over, how could that be anything other than intentional? Are you claiming the driver of the truck had a stroke or something?
well, I mean, the truck that was on the property, it's a large truck, a big box truck. I just recently had one come in my driveway, not just a month ago, after losing power for almost a week. Those trucks are huge. The floor of the cab probably sits above where my head is. I'm 6'1", I'm not that short. Now they had to navigate what I have, just a regular driveway. In this case, they're navigating a rural area. There's no lights, no light posts. It's dark. There was a recent windstorm that caused the power outage. There was a lot of snow on the ground. So the conditions, I think, were stormy conditions, at least that would cause the driver to have, maybe not clear visibility of where they are, especially with no lighting. They accessed the pole, which plaintiff complained of. Plaintiff called consumers. He was the customer. He had
Right.
lost power.
It seems to me everything you're saying, you could equally plausible explanation would be accepting the complaint as pled, true, that it was intentional. I mean, it strikes me as a genuine issue of material fact.
Respectfully, Judge Cameron, I disagree because when you look at the motion on a C7 basis, consumers, we submitted responses to interrogatories, so a sworn statement from the defendant explaining what had happened, that it wasn't intentional, that they went over the conditions that I just described, that the reason why they were there on the property. I think that evidence was sufficient for purposes of the C7 motion to at least flip the burden and put it on the plaintiff now to come forth with evidence, because now we're outside of the pleadings. So to come forward with evidence to negate that assertion.
Well, isn't
that
the
proof.
evidence your client's own admission that it knocked down like, what was it, 14 trees? Do I have that number wrong? What
It was
the number?
it was like 12, 13,
Yeah,
14.
there's your evidence.
Just-
A, your client admitted to it. B, you got photos that show it. How is that not a created question of fact?
And your client has an easement on a different piece of property and correct? Am I correct? And did not use that easement?
I think, well, I guess I'll address.
Oh, go ahead.
Sorry. Coming at you from all
I know,
directions.
yeah. All right, if I could address Judge Wallace's question first.
Sure.
I do not think that the mere driving over the trees and damaging the property establishes intent. There has to be.
Even though there were 14 of them?
Yep.
That doesn't even create a question of fact in your mind.
No, I think, well, no, because what was the evidence that plaintiff produced to create the question of fact?
Your
as to intent?
admissions and the photographs.
But with respect to most of these trees, they were, I think, saplings. They were small trees, maybe about a couple feet tall. We're talking about a boom truck that is massive. Just by the fact of getting on to the property, One, if they
Well,
couldn't see,
doesn't by definition, your client takes this massive truck based on your own admission onto a property that has no actual legal authority to enter? How is that not intentional?
they believed that they had the authority, and it's our position that under the rate book, they did have the authority to access plaintiff's property as a customer to restore power.
It was posted no trespassing, was it not?
Plaintiff there were photographs of no trespassing signs, but I don't think that would negate a utility company's right to,
Normally,
Come
they have an
to-
easement. So yeah, normally that's true. They didn't have an easement here.
There was an easement that they could have used across another property to get to the same pole. Am I remembering the record correctly?
that was what was alleged. There were never any records in the trial court record, like from the county register of deeds or a plat map or a copy of a recorded easement. So I'll take, I think for purposes of C8, we'd have to take plaintiff's allegation that there was an easement to the neighbor's property. But again, it's the middle of the night. It's dark. We're in a rural community. There is, by the photographs, a great deal of snowfall on the ground covering a number of those small trees, which they may, not have even seen them. And wind gusts that caused the power outage. So I think that they had a right to access the property for purposes of restoring power to plaintiff's home. And I don't think that the mere driving across the property establishes that consumers had the specific intent to damage the trees. Because again, under the case law, it's not whether the defendant had intent to do the act that eventually led to the damage of the tangible property.
But you would agree that it doesn't have to establish specific intent. What it has to do is it has to create a question of fact where some reasonable juror could determine, yeah, they did this on purpose. That's all they're required to do here, right?
Sure, but based on, again, plaintiff did not, in my opinion, come back with clear and decisive evidence to negate consumers' motion for summary disposition, which was supported by documentary evidence outside of the pleadings.
What's your response to the question I raised the opposing counsel, which is why didn't this claimant just make a PPI claim? I think you talked about that earlier, but I mean, it seems like maybe what's going on here is that they're trying to evade the statute of limitations because they blew the statute of limitations. So now they're filing this case based on the intent exception.
Yes, and from what I remember in the trial court proceedings, and I think what brother counsel said was he was not the first attorney on the file. So whatever happened with that first attorney, no one really knows other than the plaintiff himself. And that's not really part of the lower court record. But
so they actually did submit a claim, but we all know that's not good enough if to sue within a year. So they did submit a claim, right?
after the 1 year limitation.
Oh, they actually submitted it after.
No, I thought we were talking about the filing.
I'm talking about a written claim. Did they submit a written claim for the property protection insurance within a year? Not that it would matter because you have to sue within a year. We know that. But the question is, did they submit a claim?
Not to my knowledge. I think we're dealing with just the filing of the complaint, which was a little over 2 years after the fact.
So this earlier lawyer that we're talking about, he never had any interaction with your client or its insurance company?
Not with me, Your Honor.
I didn't say
but
you.
Well,
If you don't know, it's fine. It's always fine to tell us you don't know the answer to something.
yeah, I don't know the specifics of
Okay.
any pre-suit discussions with,
You just know there was some
predecessor.
lawyer out there. You have no idea what he did.
correct.
Got it.
As to, where was I?
Sorry, I didn't mean to put you off
Yeah,
track.
I mean, this is a straightforward case.
Yeah.
We understand the facts. We
Okay.
understand your position.
Yeah, as to, what I was gonna say was, with respect to what plaintiff knew that the statute applied for property protection, they made a pretty concerted effort in the trial court to strike consumers' affirmative defenses as to these statutes at issue. So I think they knew they were up against the 1 year statute of limitations period. But this claim, even though styled as trespass and negligence, which was dismissed by agreement, was the only way that they could circumvent the statutory exception. Absent any further questions, I will rely on my brief. I'll note for the record, I'm no poet, but I really did like Judge Gillis's opinion from Fisher v. Lowe. I probably in my entire life, I probably can't write something that's succinct and poetic for such a topic such as
Was
this.
that literally the entire opinion?
It was, and my understanding is there was a footnote that went into
Standard
some-
review and
some
everything else.
facts and
Oh,
standard of review.
okay.
Whether or not that's dicta, I don't know. That's for another day. Probably a discussion outside the court. But Your Honors, based on that and the briefs, we request that the court affirm.
Okay.
Thank you.
Our appellant, and no rebuttal, I understand. Okay, thank you very much.
Sure.
Thank you both for being here. The matter is submitted. You're welcome. Turning now to item number 15, consolidated cases, Dempster versus State Farm Mutual. Item numbers 374546 and 375033.
Morning, Your Honor. Nathan Sherbarth on behalf of State Farm Mutual Automobile Insurance Company. I'll keep this really brief. I know the court is familiar with the briefs, and I just want to talk about a couple key points. This is really a narrow issue, whether attorney fees are owed where there was a bona fide factual dispute as to entitlement to future wage loss benefits. And I think the sequence of events is important to keep in mind. The timeline here is really important and supports that State Farm acted reasonably in cutting off benefits when they did. The accident occurred September 13, 2021. State Farm paid wage loss benefits to Mr. Dempster for months. On December 8, 2021, they sent him to an IME with Dr. Chris Shaner.
Can you give me, tell me again the date that Dr. Schoener conducted his examination?
On December 8, 2021.
Number 8, 2021.
Correct.
Not 2022?
That's correct.
Okay.
It's in appendix, page 297 of our appendix, has his conclusions from his December 8, 2021.
That was a question I had, is because your brief, and I don't think you wrote it, right? This is not, did you write the brief?
I did not write
Right.
our brief. I think Appelli's brief references a 2022 date. Says that the IME was done December 8, 2022.
Because you indicate in your briefing, both IMEs were done before the termination of benefits, which
That's correct.
makes sense to me. Why would you get an IME after you
Correct.
terminate it? That's what you represent in your brief, yet I got a different impression. Which is accurate.
Yeah, same here.
It's so the timing is if you look at Shaner's opinion is on, I think it starts at page 291 of our appendix. And the date of that exam is December 8, 2021. So State Farm is still paying wage loss benefits when they send him to this IME with Dr. Shaner, the PM&R. And then they continue to pay benefits. Dr. Shaner opines he would have needed 2 to 4 weeks of work restrictions. By the time he saw him 3 months post-accident, he had returned to pre-accident status and could return to full activity levels. Given that there were neurological concerns as well, State Farm continued to pay the wage loss benefits. On July 15, 2022.
I'm interrupting you, sorry.
No.
So even after the first IME, Dr. Schreiner, IME, benefits continued.
That's correct, Your Honor.
Okay, go ahead.
Because there were two components to the claimed injuries. There were the back injuries. Dr. Shaner saw plaintiff and said the back injuries have resolved as 3 months post-accident. And then there's the neurological component. And so the neurosurgeon, Dr. Jaganathan, I'm probably butchering his name and I apologize. He examined plaintiff on July 15, 2022. So at the time, again, plaintiff is still receiving wage loss benefits from State Farm. Dr. Jaganathan concludes that plaintiff could return to pre-accident activity levels, that there's no lingering effects from this motor vehicle accident, and that he has no occupational restrictions. That's at page 306 of our appendix.
Did he look at the neurological and back issue or just neurological?
Dr. Jagannathan looked at only the neurological issue as a neurosurgeon. So Dr. Shaner already concluded there's no more lingering back issue as of December 2021. And then as of July 2022, Dr. Jagannathan concludes there's no neurological component remaining. And then 3 weeks after receiving the IME report from Dr. Jagannathan, State Farm cuts off wage loss benefits as of August 6, 2022.
Thank you.
So that's the timeline. I know the court's very familiar with the case law. We think this is on all fours with Moore v. Secura. There was no, this is not a post hoc justification of cutting off benefits. State Farm paid wage loss benefits to Mr. Dempster for 11 months. And after concluding from 2 different doctors that he had returned to pre-accident activity levels and abilities, they discontinued further benefits. I want to point out the recent Zielinski v. Auto Owners case. It's a recent published decision of this court, docket number 371692. And I think it's important to look at Zielinski because it's a published decision that discusses bona fide factual uncertainty. And I think this case is very distinguishable from Zielinski. In Zielinski, the court concluded that auto owners did not have a bona fide factual uncertainty as to the benefits when they refused to pay because they had acknowledged an injury. And then after the fact, after they denied payment, they obtained an IME that said the benefits were not necessary. So, the timing here is 2 IMEs conclude that no benefits, further wage loss benefits or any further work restrictions are necessary. And then benefits are cut off. In Zielinski, you have the benefits are denied, then an IME is done. And the court said, this is not a bona fide factual uncertainty. You can't post hoc justify your actions.
But, like 18 years ago, the Michigan Supreme Court said, listen, when you're the insurance company and your own expert that you hired, when that expert or experts plural, when their opinions differ with the opinions of the treater and you decide to side with your experts, your hired experts, as opposed to the treating physicians, you run the risk that ultimately, you may end up having to pay those benefits and pay attorney fees. That was 18 years ago. Why does Moore versus Secura not suggest that you're stuck now with the attorney fee?
Because Moore concluded that where that bona fide factual uncertainty exists, yes, there's always a risk. But bona fide, the question is whether that factual uncertainty is bona fide. And in this case, I would submit that it is, because State Farm has 2 IMEs saying that he does not need further treatment. And
the number of expert opinions that you procure isn't dispositive. You could get 10 experts to say the same thing, and that's not dispositive. Fair to say?
that's fair to say, but I think there's a fundamental distinction between whether benefits are ultimately owed and whether there's a bona fide factual uncertainty when benefits are discontinued. And
Your point is, if you relied exclusively on the video and you didn't have any IMEs, you would be in far more jeopardy of paying attorney fees than if you had the video plus an IME.
you're referring to the surveillance video?
Yes, surveillance.
Yeah, that's
Or,
correct.
and then you'd be in a stronger position if you have a surveillance video and 2 IMEs.
That's correct, Your Honor. And I mean, ultimately, there has to be some breaking point, right? Because if
It can't be just you lose at trial, therefore you pay attorney fees.
exactly, and this is a split decision. I mean, there were no, they were seeking further medical benefits. The jury found he was not entitled to those, that those did not stem from the accident. They did find wage loss benefits owed. We can't dispute that, but ultimately, as Moore says, refusal can still be reasonable even where it's later determined that the insurer was required to pay.
So, sir, do you have Appendix 2 with you?
I have, yes.
Can you take a look at, I think it's page 159. It says that it's the Schauner report is dated December 8th, 2022. are you telling us that's a typo or?
I apologize. I'm trying to find it right
No,
now.
I
Take your
understand.
time.
We just want to get it right.
No, I understand. I don't have that page with me.
Okay.
We'll see what, happily, whether we have an agreement on the issue. If we don't, then we'll cross that bridge when we get there.
Sure. My understanding was that it was completed before, but obviously if the report says something different, then the report says something different. And I'm not going to try to counteract that. At the end of the day, there was a bona fide factual uncertainty and therefore it was reasonable to discontinue further wage loss benefits. I'm happy to answer any questions. Otherwise, I'll reserve time for rebuttal.
Oh, thank you.
Thank you.
Morning, I'm Carl Edwards. I did handle the case below. And it's December 2022. What happened was the neurosurgeon report was done by the claims adjuster. The Shaner report was done after we filed the first party case for no fault benefits. And so Shaner came after Jagannath, not before.
You ever, just out of curiosity, that confuses me. Why would you have, it seems to me that you would want to get your IMEs done before you make a decision to terminate benefits. Of course, you're going to say, well, that's the problem, but you were also in the trial court.
I can't answer for the defendant. All I can tell you is that Shaner came after.
Okay, that's fair enough.
The neurosurgeon.
But there's certainly nothing wrong with the insurance company hiring additional experts.
I think that's exactly what they were doing, Judge
Yeah.
Wiles. They were trying to, assuming that we'd be at a place like this or in front of the jury at some point. That's exactly what they were doing, trying to buy some insurance. Okay. I think this is a classic case that the preponderance of the evidence says that there is no factual uncertainty. The jury certainly didn't find that. The jury concluded, even though they didn't give medical benefits, they concluded that the defendant was State Farm was overdue. So they gave.
Well, should that give us pause? I mean, if even the jury wasn't sure about the ultimate outcome here, is that evidence that perhaps there was a bona fide dispute that prevents the taxation of attorney's fees here?
Not if they say that the benefits were overdue, Judge Wiles. And then if you look at the chronology of the case, it's very important. Chronology is there was a motorcycle accident in 2019. And there's the MRI. And as you all know from the record, the MRI didn't show any herniated disc, didn't show any fractures whatsoever. And then this very crushing incident in 2021 happens, and all of a sudden 3 herniated discs on the MRI. So let me just start there. So when and a pars fracture. So Mr. Dempster goes to the emergency room the day after, although Jagannath says he didn't go for several days, which wasn't true. He went the day after. And then he goes and sees the Beaumont 3 days later, and they say, I
don't want to interrupt you, but we've got the facts down cold.
Okay.
I mean, this is a very narrow issue.
Yes, it is.
Post-trial.
Yes, it is.
I mean,
But I was just laying that as the Foundation.
Yeah.
Dr. Shaner, and this is significant. Dr. Shaner said that the treatment by the neurosurgeon, Dr. Hausman, was appropriate. Dr. Shaner says that the man cannot drive because he's taken narcotics. So there's no uncertainty that he's disabled. You got the neurosurgeon says he needs 2 surgeries. You have then the physical and rehabilitation medicine doctor, Dr. Marshall, saying that he needs restrictions. And even with the video, Judge Cameron, Dr. Marshall said, I don't want my patients to be laying in bed. I want them to be moving around. So the fact that he might have vacuumed the back of his car for a couple of minutes, he said, that's within what I want him to do.
I don't think that's listed as a restriction on whatever medication he was taking.
Yes, yes, but that's what the testimony that the jury heard. So I think the preponderance of the evidence says it's not a bona fide uncertainty where you got the treating neurosurgeon says he needs 2 surgeries and he can't work. You have the treating physical rehabilitation medicine physician saying he can't work. He's a long distance driver. And you got Dr. Shaner saying the defendant's IME in December saying, I agree with the treatment that was given by the neurosurgeon, Dr. Hausman, and I agree he can't drive.
I mean, the fact that's most in your favor is the standard review. Frankly, if the trial court would have done the opposite,
Yes.
I'd be affirming, but the question is whether the trial court abused its discretion.
That's true. Whether this is within
So,
the outcome of reasonable outcome.
In my mind, your
Yes.
best argument is the standard review.
Thank you.
Okay, thank you.
Very brief. The fact that the brother counsel mentioned the restrictions on Norco for driving, there was evidence that, I mean, frankly, we don't need to get into this. It's not really relevant to any of this. It ultimately boils down to whether State Farm, when they cut off benefits, had a bona fide factual uncertainty. I submit that they did based upon the IME report of Dr. Jaganathan. I do not know the timing on the other. I could not
I
find.
think is it Mr. Sherbar? He did the briefing, didn't he?
I am.
Oh,
Mr.
he is.
Oh, you
Sherbar.
did. You did. No, I'm sorry. Who did the briefing? It wasn't you. Who was
Mr. Freshour,
Freshour?
my office.
have a conversation with?
No. No, but the point remains the same. We had the IME report before cutting off benefits. We paid benefits for 11 months. And ultimately, I leave it to the court's discretion and consideration. But if it's not sufficient to have surveillance and an IME before cutting off benefits, it begs the question when we can establish a bona fide factual uncertainty in cases involving discontinuation. I'll rest on a brief.
Thank you very much.
Thank you.
Thank you.
counsel. It's always nice to see you, sir.
All right, that matter is submitted. Turning now to item number 16, Ragsdale versus Machado Armanda, MD. That's item number 376057.
Morning,
Morning.
Rob Kamenak. I represent the plaintiffs. I'd like to reserve 5 minutes for rebuttal or the balance of my time. I'll start off the argument with the following. I've never seen a case scheduled for oral arguments so quickly, 2 months after the last brief was filed. I've just never seen this. I'm hopeful
This is good then.
that compliments to the court.
Okay.
But I also believe therefore that whoever was reviewing this ahead of time, including the 3 of you, that this is a fairly clear-cut case. So this is the case in which the gentleman, 46-year-old Mr. Ragsdale, was on the table. He was undergoing a procedure. The table was tipped over head first. It was also slanted to his left and he fell off the table. The issue before the court deals with proximate cause. And in particular, the court is therefore to assume that there was negligence and whether or not there's evidence of a connection between that negligence and the injuries that were suffered. Actually, there's not a lot of debate about what the injuries are. The only question is whether there's a causal link. I must confess, having been up here many times, I was really perplexed by the court's ruling here. When you go through her statement, and Judge Kunke's a fine judge, don't get me wrong, but on this one, I think she missed a 2-centimeter putt. She said that I was hoping something more in response to the motion. I think that's a really insightful statement. Number one, it acknowledges that something's there. And number two, it acknowledges that she just doesn't believe it was enough. And then
But
she's
perhaps it acknowledges that your former colleague could have done a better job on that brief.
well, perhaps.
I thought, I took that to mean that she was rooting for you.
Well, hopefully. But, and who knows, because, and again, I don't want to read too much into it. Mr. Sedaris, as you know, his oral argument was probably a paragraph long. So maybe she was just talking about it, the oral argument. I don't know. But I do find it's a curious statement. And then she makes the following statement, and then I'll get into the argument itself. Whether Mr. Ragsdale has less than perfect function. Perfect function. I mean, that's not a standard. There's material if expert testimony links the injury to something that happened at U of M. That has not been demonstrated. I think that is a little bizarre. So, med-mal case, we all know the rules. You have to have qualifying expert testimony. And here there were 42 exhibits that were submitted to the court, 22 exhibits submitted by the defense, 20 submitted by the plaintiff. All sorts of evidence, including deposition testimony that established a causal link. I will not go through all of it. I will go through just, I don't think you have to go any farther than Dr. Frank's testimony and his report.
Are the first 6 exhibits somewhere in the lower court record?
No, I could not find them. Starting with, and as you know, Your Honor, most of those deal with photographs and more of an explanation of the table and how some of this works. The substantive, if I can use the term, the substantive exhibits are thereafter, starting with Exhibit 7. They were submitted to the trial court. You can look at the docket sheet. The entry was April 9th. So, and I did subtract out the 7, Your Honor, when I said there were 42. So even this English
6.
major can do. So, excuse me, I even get that wrong. So,
No.
but in any event, you have Dr. Frank's testimony, and he said that the plaintiff sustained a major injury to his cervical spine, presumably from the incident. And he says the incident caused a large protruded herniated disc at C3, C4, also at C5, C6, and also that there was an injury to the alar, I think that's how you pronounce it, alar ligament. That is a ligament that if the court, it's explained in the brief, but just to be clear, that deals with a structure that connects the skull to C2.
It seems to me the most important thing that you just said was the phrase presumably related to the accident.
Mhm.
I mean, that's what we're here for, right? That the causal link.
Right.
So, in terms of Dr. Frank, he said that in terms of what happened in the operating room, he was relying almost exclusively on what the patient told him. Of course, the patient was unconscious. So
Mhm.
what was the basis for the patient to say that? And that's what I couldn't.
Well, let me address it at a different angle and see if this
Okay.
satisfies the court. Dr. Frank did do a physical examination of the plaintiff, and it took place on September 13th, 2023. Because, to be clear, the plaintiff went to Dr. Frank, who's an expert on C1, C2 injuries, for treatment. He didn't go in for just an evaluation. Now, he was evaluated. And so, by way of foundation, because there is a challenge to the foundation here, Dr. Frank actually examined the plaintiff and examined the medical records, and from there came up with his opinion. If there is a weakness, if at all, on foundation, that does not prevent or justify the grant of summary disposition. The strength or the weakness of foundation for an expert's opinion is something for the jury to consider by way of weight and credibility. And the case law on that is pretty clear. Matter of fact, I think in the Judges Maldonado and Judge Wallace, I think last year, if I may, you had a case involving a punctured breast implant, if that rings any bells. And the similar issues were brought up in that particular case. I listened to the video yesterday. Mr. Cook argued on behalf of the defendant. So again, otherwise the foundation was all the imaging that had been done, the specialized imaging had been done and the like. The mechanics of how the injury took place can be reconstructed as far as I'm concerned, Your Honor. And that's something that the jury can say, well, they did a good job on that or they didn't do a good job on it. But that's a question of fact for the jury. I don't know if that answers your question.
Yeah.
Or if it does in a sideway equation.
Right.
So, so you have his opinion. You also have his report. Again, I think the law is pretty clear on this, that the report need not be admissible at this stage. It just has to be in a form that can be placed into admissible format for the jury. So the report is indicative too. But you go beyond that, and you also have Dr. Abraham. And Dr. Abraham also had a report. His deposition, I reread it last night. I don't really think he gave an opinion in his deposition. And we also know that his report can be put into admissible form for a jury at the appropriate time, because with the motion for reconsideration, he filed an affidavit. And he too comes out and he talks about the causal link. And he's the one that says that he believes, based on what he has reviewed, and that includes the specialized MRI, which is very important in this case. And I'll get into that in a moment. But he ordered it, he reviewed it, and he said in his opinion that he had a 95 degree of confidence that these injuries that we're talking about resulted from the fall. And that all he has to do is go above 50%. He went to 95. I won't quote his testimony. There's a couple other things I'd like to get into.
I'm sorry, which expert was that?
Abraham.
Yeah, okay.
There is some discussion about whether we could rely on the defendant's exhibits. I think the answer to that is yes. I assume the court is familiar with the new Bowen case that came out. Maybe you're not, and if I do, it's published. It came out after the time for submission of supplemental authorities. I have the.
That's always been the case, right? I mean,
It has.
you don't have to reattach a full deposition transcript if the motion that you're responding to already has it.
Well, and I have copies if you wish I can give to the clerk.
I think
Okay.
you win on that issue.
Okay, fair enough. Carried it for nothing.
That's all right.
Well, Bowen says, of course, we can rely upon the defendant's exhibits here.
Just,
No problem there.
let me run something by you, and you explain to me why I'm wrong about this. I got the feeling reading this, that this was a trial attorney who either accidentally or intentionally didn't provide certain key information to experts, like the witness statements of people who were in the room. It seems to me that those are things I would want my expert to take a look at. And the experts didn't have the benefit of those witness statements. So the people that actually were there to see the sliding or the fall, none of that was provided to the defense. And I'm trying to figure out, was that strategy? Was that an oversight? Or was it, I think what you're going to say, is unnecessary?
Sorry.
Well, I'll definitely go for door number 3, if I
Okay.
can, that it was unnecessary for the reasons that I said earlier, because I think it deals with weight and credibility. But to go to the first 2 points, I don't know. As the court knows, I I entered this case at the reply brief stage of the proceedings. And that's not suggesting that the prior filing wasn't very good. I'm just saying I wasn't involved at that point. And obviously, I'm not trial counsel. So I don't know.
I mean, experts are allowed to rely upon medical histories given in records, right? So if you've got a medical report that says patient fell off a table, then that expert has the right to rely upon that history in the actual medical record. Even that.
no doubt, and that history is in the medical records. And the experts reviewed the medical records. Also, even for purposes of foundation under a C10 motion, it's not just the proper use of circumstantial evidence with respect to a genuine issue of material fact, but circumstantial evidence by way of analogy can be used if the court were to find that there's a need for further foundation. So, yes, I think there's plenty in this record. I'm going to repeat, I'm not a judge and I never will be, but I was very surprised that Judge Kunke granted this motion. I was stunned, actually.
Why don't you talk about the photograph to the face for a minute? Give us some context for that. When was that taken, and
I don't know, Your Honor.
is that somewhere in the brief?
Not when it was taken. I don't recall that being in the brief. I reread it this morning.
I don't mean the exact date. I mean, was it within like a week of falling off this table, or was it longer than that?
But that is my understanding. I can't say for sure.
Okay.
Yes. Otherwise, swelling can reduce over time. And I'm sure that's one of the reasons why the court asked the question.
Talking about the one that shows the bright red spot on the side of his face.
Understood.
Okay.
I guess the only other point I have to make, unless the court has, well, I have 2 points. One, Doster, the court is familiar with the Supreme Court order in Doster, and that is that, a court is not to go about weighing evidence. It's just to decide whether there's a genuine issue of material fact. That's pretty well established. Lastly, and I can address this in rebuttal, but I think I'll do a preemptive strike on the claim of speculation. I have argued Skinner for the defense many times, and I've also now, the last 5 years, dissected Skinner, and I do think that this whole notion of proximate cause on Skinner is misunderstood. I'll say this, when you go into Skinner, what had happened is the expert was asked to assume facts that appeared nowhere in the record. Not at all. So it was a hypothetical that was given to the expert. In that context, with respect to the lack of any evidentiary support for the basis of the hypothetical question, the Supreme Court found the speculation. That's not what we have here. Any claim of speculation, I think, really is more of an attack on weight and credibility of the expert's opinion. So all that being said, I'm not going to get into the argument about Bryant and common knowledge exception, all that, because I think the first argument subsumes all of that. So I'm going to ask the court, unless you have questions, to affirm, and I'll save the rest of my time for rebuttal.
No.
Excuse me, to reverse. Thank you.
Old habits die
Yeah,
hard.
I was just gonna
You
say.
do. Exactly right.
Good morning.
Morning.
Karen Beach on behalf of the defendants. I'm going to ask the court to take that as a judicial admission that this case should be affirmed. I'm going to talk about some of the factual issues that popped up during Mr. Kamenek's argument, and then I'll circle back to the law. The photograph was taken, according to plaintiff's brief, page 17, 56 hours after the incident. That's over 2 days.
Well, isn't that by itself proof of an injury caused by this fall? I mean, you've got somebody that wakes up and is complaining to pain to the jaw and the face, to the extent that the original imaging study suggests he might have actually broken the jaw. I think that was later debunked. But you've got a photograph that corroborates his testimony about an injury to his face. How is that just by itself not sufficient proof of an injury caused by this fall?
You've got a photograph of bruising and swelling to the face. He did slide off the table. His head and neck were cradled by the CRNA as she lowered him to the ground from the 1 foot that he was off of the ground, that friction on her body or whatever he was sliding against could have caused that arrhythmia. But her testimony was clear that his head and neck never hit the ground.
Okay, well, that's enough. If the friction caused an injury to the face, that is an injury to the face. It's not a huge injury. I think you'd have a tough time convincing a jury to give you very much money for it. But how is that not an injury caused by this fall?
Your Honor, that's not the injury he's trying to recover for. He's never claimed that he's permanently disabled from an
Oh,
abrasion
it
to his
doesn't have to
face.
be a permanent, do you have to have a permanent injury to have a med mal claim in the state of Michigan?
No, Your Honor, but this whole case has been about the vertigo, the dizziness, the damage to his ligaments. So the defendants are justified in focusing upon that as the injury that has been claimed and pled. And certainly there's nothing in the lower court pleadings that would preserve that injury claim. And that's the same for the aggravation and the open incision arguments. They're not preserved for appeal. They weren't.
So he
made
never
below.
argued that he had an injury to the face?
He argued that he had an injury to the ligaments in his neck. Not that,
The answer to that is yes, then a plaintiff never in this case has ever argued that he suffered an injury to the face as a result of this fall, correct?
I don't believe so, Your Honor.
Okay.
As Judge Wallace just noted, the notion that plaintiff had a jaw fracture from this incident was debunked by the subsequent CT scan. And I saw a reference to the jaw fracture pop up a few times in plaintiff's reply brief. So I just wanted to make that clear. And that's from page 92A of the plaintiff's appendix, that there was no jaw fracture. So Dr. Machado is the one who wrote the note speaking about the experts relying on what happened in the medical records. He wrote the note about, quote, probable head or neck impact. But if you look at his deposition, he was not the one who witnessed the fall, because he was looking at the camera display of the laparoscopic surgery happening within the abdomen. He was not looking across the table to what was happening with Mr. Ragsdale's head. So again, the CRNA confirmed that he slid, she caught him, his head and neck never hit the ground. What we are missing from the lower court record that Mr. Kamenek referenced is the affidavit by Dr. Abraham. It was discussed in the motion for reconsideration that plaintiff filed, but that affidavit, like the other new exhibits that plaintiff tried to file on reconsideration, never made it into the lower court record. And I did go down to Washtenaw County and look through the court file to see if I could find any of those exhibits other than exhibits 7 through 26. So those are the complete set of exhibits. This affidavit from Dr. Abraham, which I think, may have supplied some of that missing causation testimony, that was never before the trial court, either on the original ruling or on reconsideration.
What were those 6 exhibits? He said that it was some tables and a bunch of photographs. Was there anything else?
I think he's characterized that mostly correctly. I've not looked back recently to see what those exhibits were, but it's more the exhibits that were offered on reconsideration that I think, and plaintiff counsel realized that he A, didn't file the exhibits, and B, didn't identify what created a question of fact. He tried to backfill that record on reconsideration.
What about the affidavit of merit? That was part of the record.
Affidavit of
Could the
merit.
trial judge not have taken that into consideration?
She could have if Dr. Bell was planning to offer causation testimony at trial, but he specifically testified in his deposition that he was not going to be a causation expert. So those opinions,
I thought Dr. Sabir was the person that authored the original affidavit of merit.
the original affidavit of merit, yes.
So why couldn't the trial judge have taken that into account?
Because it was superseded by the affidavit of Dr. Bell when plaintiff substituted Dr. Bell as the standard of care expert.
Was it ever stricken from the record?
It was not stricken, but it was replaced. So just like if it had been a defective affidavit of merit, it's replaced by the new one that's filed by Dr. Bell.
Well, was it replaced or was it added? Is there some order that says the Dr. Bell affidavit of merit replaces the affidavit of Dr. Sabir?
All I know specifically is that Dr. Sabir was withdrawn as the standard of care expert. He was replaced by Dr. Bell. And then Dr. Bell testified unequivocally in his deposition that he was not going to be offering causation
Well,
opinions.
if this was an issue at trial, then of course, you didn't call Dr. Sabir. You can't rely upon him at trial, but this is an MSD. And so the trial court's allowed to look at everything in the record, correct?
Well, everything in the record is putting more of a burden on the trial court than the trial court should have, and that's under Barnard. But if we're talking about Dr. Bell's affidavit,
No, I'm talking about Dr. Sabir's affidavit.
I don't think plaintiff has ever argued that
didn't see it.
she should be relying on Dr. Sabir's affidavit. I think he was quite clearly withdrawn as an expert. So I think of his affidavit of merit, if he's been replaced as the expert, then his affidavit of merit is defunct. It's no longer
I
properly
thought,
part
I
of the
thought
record.
in the brief that we reviewed for this case that had been argued, but maybe they were talking about Dr. Bell. Maybe they weren't talking about Dr. Sabir.
I've only.
I'll go back and look. It's
Okay.
either there, or it's not.
My recollection is that they've only talked about Dr. Bell. They have not talked about Dr. Sabir, because when you said Dr. Sabir, I was like, who is that? So I don't think I'm familiar with them relying on Dr. Sabir. So getting to Dr. Frank's testimony, which is the only testimony that was quoted in the response to the motion, what did Dr. Frank think happened to Mr. Ragsdale? Dr. Frank said in his deposition that he was told by plaintiff that plaintiff flipped off the operating table and hit his face and head on the floor. That is hearsay, and it's not accurate. And I think it's interesting that plaintiff cites to Badalamenti in support of an argument on circumstantial evidence, because the holding in that case was that an expert who discards the eyewitness testimony of treaters cannot create a genuine issue of fact to avoid summary disposition. So to the extent Dr. Frank is relying on this inaccurate hearsay to support his opinion that this man suffered significant head and neck trauma when he flipped off the operating table and landed on his head and neck, it's not competent to create a question of fact. You're correct that he didn't examine the defendant's testimony of what actually happened. And I would further note that Dr. Frank as well is not going to be an expert witness at this trial. There was an order entered limiting the expert testimony on causation at trial to Dr. Abraham only. So I think it was incumbent upon plaintiff to come prepared with the evidence from their actual causation expert to create a question of fact for trial, and plaintiff did not do that. Discussing the Aller protocol MRI, it occurs to me that if this ligament damage that is shown on the special MRI doesn't show up on a regular MRI, then it's entirely possible that this ligament damage predated the filing of the lawsuit and the accident, and it just never showed up on any of the previous MRIs plaintiff had.
Which one of your experts said that?
I don't think any of the experts said that, but it occurred to me as I was reviewing the case that if it's this invisible damage that only shows up on a regular MRI, it could have predated the incident. So now getting back to the law, the Barnard manufacturing case, I think it binds this court. I think it binds this court over Bowen because it was the first out of the published decisions. And just a few thoughts on Bowen. It was decided on the pleadings. It wasn't decided on the basis of a fully developed factual record for SD. It also involved an affirmative defense of pandemic healthcare immunity on which defendants had the burden of proof. So it was in fact the defendant's burden to show that there was no question of fact in Bowen that they were entitled to immunity. And the fact that the plaintiff didn't respond to that motion didn't mean that defendants would automatically get summary disposition. It meant that if defendants didn't put forward the facts showing an entitlement to immunity, they weren't entitled to immunity. This case is different, and it's more like Cleveland Cliffs, which Bowen relied upon. Although Cleveland Cliffs is also a little bit distinguishable because here plaintiff chose to submit a brief, they chose to oppose it, so they're bound by what they identified as creating an issue of fact. And I think the law is still good and valid that this court's review is limited to the evidence properly presented to the trial court, which the Barnard Manufacturing Court said was the evidence referred to and relied on. So we've given you Barnard, we've given you Kincaid, we've given you multiple recent unpublished cases that all reinforce that it's the party's duty to identify specific pieces of evidence and testimony creating an issue of fact. You can't just expect the trial court to hunt through all of the depositions and the transcripts and the records submitted to find a question of fact if you can't be bothered to identify that in your 20-page brief and you're the attorney. That's not fair to trial courts. Finally, the final point I want to make is that the Supreme Court has held multiple times that this before and after evidence of causation is not enough to create a genuine issue of fact. And that's the Lowry case, which involved toxin exposure. So the fact that you can show that the plaintiff in Lowry wasn't suffering symptoms before the toxin exposure, that's not enough to create a question of fact on causation. And then the two other cases are Genesee Merchants Bank and West. So we would ask the court to affirm.
I would think the
There's-
one thing we should all be able to agree upon was that whatever trial attorney wrote, the response to the MSB could have done a better job.
I won't speak ill of Mr. Sidara or Mr. Roll, but I would agree with that.
I mean, I'm not calling out anybody personally, whoever that individual happened to be could have done a better job.
Thank you.
Thank you.
Judge Cameron talked about how the accident occurred, the mechanism, and how did Dr. Frank know? So I want to stress to the court the U of M records of the incident, and in particular, the record of the day in question. And they acknowledge that the plaintiff slid off the OR table. It's all in front of Dr. Frank, through the bed restraint. His left shoulder had contact. Contact is debatable what that means, but contact with the floor. The records establish that his head was cradled by the CRNA for a period of time. The expert comes back and says, with respect to the cradling, that the cradling basically, with all the body weight, jammed the neck because you've got 250 pounds coming down. And the CNRA, according to the medical records, foundational information is holding the head. So you have hyperflexion. And that's one of the things that the experts get into. So they are identifying a mechanism of injury that is supported by the foundational information in the medical records. There is no doubt that there was contact with the floor. There is no doubt that Mr. Ragsdale was 250 pounds. There is some testimony about the angle of the table. To be clear with the court, the table wasn't just that Mr. Ragsdale went down, because as you know from the facts, the only part of his body that was restrained was basically across his thighs. So when they turned him over, it wasn't just he went forward, backwards, whatever you want to call it, but also the table, which is designed, is also tilted to its left. And when the evidence is such that when it was tilted to the left, they flipped him over, and as you know, the table is used to get to certain parts of the anatomy. And he came off with all that body weight off the side of the table. He twisted.
So one of the things you mentioned the table. I heard earlier that it was a 1 foot. I don't remember seeing that in the record.
I don't
And
either.
I can ask where that came from, but that was a question I should have asked.
I think there is record evidence about the distance, but I don't know what it
Between
is.
the table and the floor?
Yes. There was contact made, but what I'm trying to stress by that last point is the injuries that I described earlier are twisting injuries. Twisting injuries. And if you look at the mechanics that talk about the table, the medical records that talk about what happened, and there's no doubt and there's no debate that he came off the side of the table. So we're not talking about straight up. But when you twist and some of the evidence gets into that, that's when you start having all kinds of, and I think the court would know this, that's when the risk of herniation obviously goes way up for all of the particular parts, C1, C2, et cetera, but also that involves the ligament tear because of the twisting. So I think that's a point I tried to stress in the reply brief. And I think that's another point that the court should take note of. As far as I'm concerned, once the court finds a question of fact, in terms of the nature of the injuries and what goes before the jury, that's for the court or the trial court to decide at that point in time. I respectfully suggest that the job of this court, if I may, is simply to find whether there was a genuine issue of material fact. So I would I would properly ask the court to reverse and remand to Judge Conkey.
One last question. When the plaintiff was put back on the table and the other surgeon, the more experienced surgeon, steps in and takes over, according to the briefs we've read here, the procedure was changed, right?
Yes, it went from a laparoscopy to an open procedure.
So what, and what did that physician testify to at his or her deposition as to why they changed the procedure? If they were deposed, I can't recall.
I don't know what they said. I can only infer, Your Honor, and I will do that with the caveat that I'm inferring. You know, who was performing you had a third year and a fifth year resident in there. They were doing the procedure, and Dr. Machado was looking at the surgery through a window. And that's all on the record. My guess is when this happened, he got in there lickety split and said, okay, we're going to do this differently. I think it's reasonable to assume that they were not about to put this man back on that table and tilt it again.
Okay, thanks.
Okay, thank you. Thank you.
Thank you, Your Honors.
All right, matter is submitted. Thank you. Turning now to item number 17, 375419. That matter has been dismissed by the stipulation of the parties. Turning to item number 18, Title Resources Guarantee Company versus Thomas Allen Francis. Item number 375599. Yes. Yes, go right ahead. All right, that's fine. Yep. Go right ahead.
Thank you very much, Your Honor. Good morning, Your Honors. Philip Newman appearing on behalf of the plaintiff appellant, Title Resources Guarantee Company.
Morning.
I'd like to reserve 5 minutes for rebuttal, please.
Yes.
A mistake was made by a mortgage lender and a title agency during the purchase and sale of a home. As a result of the mistake, Applee's mortgage loan was paid off and their mortgage was discharged. One day, they owed $284,000 to their mortgage lender, and the next day, they didn't owe anything, and they had a home that was free and clear of any lien or encumbrance. The mortgage loan on the home that was sold was supposed to have been paid off remained an encumbrance on the home after the closing. Everyone acknowledges that the wrong mortgage got paid off, and everybody acknowledges that the Applees, Thomas and Melissa Francis, did not have anything to do with the original mistake. Appellant Title Resources Guarantee Company was the title insurance company that had issued an owner's policy of title insurance to the buyer of the home that was the part of the transaction, and would ultimately be responsible for making sure that the seller's mortgage got paid off. That the mortgage that should have been paid off was still an encumbrance on the property. After the mistake was discovered, the lender and the title agency went to extraordinary lengths to try and fix the problem. But Applees refused to do anything that might allow them to solve the issue.
Well, that's not quite true. Didn't they offer to have a promissory note or an independent mortgage placed on the property and make payments in the same manner they were prior? Just in this case, it would have been to a different entity.
There was
A
some
private mortgage, correct?
Yeah,
I'm sorry?
private mortgage,
A
sorry.
private mortgage.
Yes, there was some talk about a private mortgage. That is true.
Well, why didn't your client jump on that? Or
Well,
not necessarily
my-
your
my-
client, but
yeah,
why
right.
why didn't the bank and the title company jump on that offer? And that would have made them whole, would it not?
It would have, except that I think the preferred outcome would have been to have this mortgage resold on the secondary market as opposed to being held by University Bank as a private mortgage. That was
But that's
preferred, but
that's the bank and the title company's preferred outcome. But how does that
Understood.
somehow trump the preferred outcome of this couple who had no fault in this matter whatsoever?
I understand. It doesn't necessarily trump it, but how we believe that the Applees at least had a duty to try and cooperate in some fashion.
They did
were-
though.
And they did.
They did though.
You just admitted that they did.
Well, whether they did or didn't, what's the legal duty?
They're
You said they're a duty, ethical, moral, what duty are you referring to?
But we believe that they have a duty to cooperate with trying to resolve the problem.
So what duty to cooperate? What's the legal basis for that?
Because they received an unexpected benefit. They received the benefit of a $284,000 mortgage being paid off. And so we believe that they had a duty to do something, and they say, yes, we would have signed something, but they never really completely committed to even doing that. They simply said, we
Did you
did not.
accept it? Did you accept that offer though?
So my client actually wasn't part of the original negotiations. My client came into this relatively late in the game, so to speak. Once the mistake was first discovered, the bank and the title company tried to work with the Francises to figure out some way to fix the problem. And
The reason that your client has standing in the first place is your argument is that your client, as the insurer, steps into the shoes of the insurer, right? Which would be
Correct.
the bank and or the title company.
well, they were not our insured. Our insured was the buyer of the
Okay,
property.
sorry, right, the buyer of the
And
property.
the buyer is the one who now has a house that still has a mortgage on it. And so that's why we became involved, was because we had to fix the problem. We're the stuckey, if you will, in this case, because we're the ones that had to shell out $277,000 to fix the problem.
But your client's also in the business of this very situation, right? They're in the business of insuring against something like this happening.
That's correct. And then once we pay out on insurance, then we go through the recoupment process of trying to get the money back from whoever is responsible for the problem in the first place.
The wrongdoer.
I'm sorry?
The wrongdoer.
It could be the wrongdoer, or it could be the person who benefited from the mistake in the first place. In this case, it would be the Francises. Because they're the ones who one day had a $284,000 mortgage on their house, and the next day they did not.
But you concede their hands are clean, right?
I can see that their hands were clean at the beginning of the transaction. Yes, they did. They had nothing to do with the mistake. We acknowledge that.
As we're sitting here right now, your client still potentially has a cause of action against the wrongdoers, right?
Well, I was going to advise the court on subsequent events that have happened since the briefing in this case.
Please do.
Okay. We ended up following the roadmap that the trial court had provided in the motion for reconsideration, and we filed suit in United States District Court for the Eastern District of Michigan against University Bank. University Bank then filed third-party claims against Liberty Title and the Francises. And there are a number of cross claims among all the various parties, and we have been actively litigating that case in federal court. We did try facilitation because finally we have all of the parties together in one room, so to speak. We tried facilitating. Unfortunately, we were unsuccessful. So we are in the middle of that litigation, and TRG acknowledges we do not expect the Francises to pay twice. There's no possibility of double recovery. We simply want our money. That's all we want in this case. I'm sorry?
Plus costs, right?
Plus costs, but you know, at this point, we're focusing on the $277,000 check that Title Resources Guarantee had to write in order to fix the problem. So that case is currently pending in Eastern District of Michigan. There's a motion for judgment on the pleadings that's pending before that.
And that's interesting, but none of that's in the record, and none of it is helpful for answering the legal question for us.
I mean, I asked him to tell us, so I apologize.
Sorry, no.
I was just curious. I agree with Judge Cameron. It's certainly not part of the record. I was just
Understood.
curious.
Understood. We contend fundamentally that the court prematurely granted the motion for summary disposition, that this is an equity case. We are trying to seek equity here. The court can examine the record, or could have examined the record and decided, is it okay that the Francises simply offered to just give some sort of a private mortgage and note, and what was the amount of that going to be, and what is reasonable in the circumstances?
Your client had no damages at that point. I mean, that's why the court dismissed the case.
that was something that the court said on multiple occasions during that oral argument, that at that point, we had not incurred damage. The
Well, it's
damage,
true, isn't it?
well, it was true. At that point, we had not written the check yet. So that's one of the reasons why I asked the court at least twice during oral argument, can the court hold this matter in abeyance and we'll write the check? In fact, to be honest, when I walked into the courtroom that morning, I thought the judge would take us into the back room and the chambers and say, what can we do to fix this problem?
But that's another serious problem though, which is that your client put the cart before the horse. In other words, instead of paying off the Francis's note and then filing a cause of action, it did nothing. Instead, it just filed the cause of action. It didn't have any damages. What choice did the trial court have at that moment?
Well, at that point, the court could have held the matter in abeyance, as I had requested.
Even though there was no dispute at that point, when that court was looking at this case, that your client had zero damages in the case.
That point, we had not suffered any damage other than the prospective damage of having to write that check.
You knew you were going to have to write the check and you didn't want to yet.
My client was hoping that we could work it out. My client was hoping that's the reality of the situation. My client was hoping we could work it out in some fashion, however the court felt was most appropriate and equitable under the circumstances.
We understand the legal question. Is there anything further you need?
No?
Okay. All right. Thank you.
Thank you, Your Honor.
Counsel, as you can probably tell from our questioning, I don't know you have to spend a lot of time.
I don't. I have, my wife has a fool for an attorney and a husband. So I stand here representing myself. I'll answer any questions. I appreciate that the court clearly read the email chain. The only thing I would say is neither the payer of the funds, the recipient of the funds, which ended up being Freddie Mac, the intended recipient of the funds, which was the Curtises, none of them are before this court. Thank you.
Thank you.
Anything further? Okay. Just to remind you, this is rebuttal and you don't have a lot to rebut, but go
I
ahead.
understand, but the defendants the appellants have completely avoided any responsibility in the sense of being willing to actually do something to work this out. And that has been clear throughout.
Thank you very much. Don't forget your amplifier over here.
Thank you, Your Honor.
You're welcome. All right, that matter is submitted. Thank you both. You're welcome. Why don't we only have a few more cases. Let's just take our 11 o'clock break right now. 5 minutes. All right, we are back on the record, turning now to item number 19. Consolidated cases for Parati versus Wayne County Employee Retirement Systems. Those are file numbers 372556 and 372566.
Good morning, Your Honor. This case call always confuses me. Looking, and I just looked at my watch and got the time of day wrong too. Brian Schwartz, may it please the court, Brian Schwartz on behalf of defendant appellant Wayne County Airport Authority. Robert Abb, who's at council table representing the retirement system. We've spoken and kind of to be consistent as possible. I understand the court has read the briefs and is very engaged. So
Are you sharing your time then?
I don't even think it'll be a problem.
Okay, pretty good.
I'm going to reserve some time, but I'd never even come close to using, never realized there was a maximum time here until I saw it the last time I was here. I will be very brief and mostly defer to the court. This case was never about whether plaintiff was going to receive pension benefits regardless of the outcome. Plaintiff began receiving his pension benefits at age 65. Instead, this case is about whether the Retirement Commission properly exercised its discretion and concluded that under the terms of the relevant plan documents, the plaintiff was not entitled to begin receiving deferred vesting pension benefits at age 60. In other words, there's no dispute that he gets them. The question is when they start as a deferred vested retiree.
Right, we know that. So let me ask you a question. So I was looking at the summary and looking at the plan, and I see that very clearly the summary incorporates by reference the plan on pages 4 and 5. There's no question about that. But I couldn't find anywhere in the plan where it incorporated the summary other than maybe references to the coverage group. So is there anywhere in the plan where it incorporates by reference the summary?
But it doesn't incorporate specifically by the name summary, but it does it in a couple places. One is section 1.2, where it refers to, that's the conflict provision, where it refers to both collective bargaining agreements and the plan document.
Well, the collective bargaining agreement doesn't apply here, right? Okay.
Correct. Or
So,
the-
so that brings up my next question. I'm glad you brought us there. What does that last phrase mean?
Yes, or the benefit plan document, as
Yeah.
Mr. Abel also explained that how the retirement system and the airport authority have consistently treated that plan document for at-will employees is that summary of benefits.
Okay. Does it say that anywhere in the actual document?
It does not in the document, in the plan document, but it's in the but it's consistent past practice, and I believe that's part of the record as there are letters from Linda Racy that are also in the record. I believe one of them is attached as the sorry, I believe it, appendix. Actually, that's not I was thinking of a different letter.
So forgive me because I'm sure this is in your brief and I just don't remember. Is there a published case that says that it could be based on past practices, even if it's not in the plan?
Well, if it's clear, if the contracts are clear and ambiguous, we believe that you got to look at both of these. The contract is not just one document; it's both documents together.
What? No. Now you're moving on to the next part.
Okay.
Question is, we know that it's not referenced explicitly in the plan that it is this summary. Okay, but what you're saying to me is based on past practices, it's always been treated as part of the plan, even though it's not mentioned in the plan by name. So is there published case law that says that's okay, that yeah, in fact, based on past practices, the summary can be incorporated into the plan, even though it doesn't say that?
Yeah, I believe there is, Your Honor, and just generally speaking, if you don't include
What case is that?
So I'll get to it in a second, but if you don't include the summary, you have a silence in the plan about when those benefits begin for deferred vested retirees, and if there's silence that equals an ambiguity, then you could use general rules of contract interpretation. And on the specific case to look at that, external past practice as evidence of kind of the course of dealing with the parties.
But that's if the language itself isn't clear.
Correct.
And the one, if I remember correctly, the plan doesn't say at all. It's not that it's ambiguous, it's that it doesn't speak to it, whereas the summary is clear.
Correct. So I guess to put our argument in clear, we believe that there isn't just the complete contract is both documents together. It's the only way you get an answer to the questions without an ambiguity, and there is no ambiguity. And I don't think the other side's arguing an ambiguity. If you're only looking at that plan document, the one with not the summary, the plan document, it leaves open the question of when do these benefits start? It's not answered there. It's got to be answered somewhere. So there is arguably either an ambiguity or some sort of determination you have to make, even if it's, it's got to be made in the contract. And even if it's not as clear about when it is, that's when Mr. Abel gets to this too. You have to defer to the Retirement Commission's determination of how to apply the plan.
Here's the other thing I guess I need you to help me with, because it seems like there's a conflict between the summary and the plan in a in an unusual way, and here's what I mean by that. So assuming we accept your statement here today, that the plan document is the summary. We look at the defined benefit plan itself, and it says, if there's a conflict between the defined plan benefit document and the plan document, then it's resolved by the plan document. So that would be resolved by the summary. But then if we look at the summary, it says the opposite. It says if there's a conflict between the summary and the plan or the defined plan benefit document, then we look at the defined plan benefit document. So they both say the opposite. They both say if there's a conflict, look at the other document. So am I reading that wrong? Because I probably am.
Well, I will agree that it's not the model of clarity, but there is evidence in the record about how that has actually historically been treated. That was the letter I was thinking about before.
So am I reading that right, though, that they both conflict with one another on that specific point as far as the actual text of the documents is concerned?
The pure text, if you don't have any information, I could see how someone could think that. But as the letter from Linda Racy, which I believe is appendix, it's attached to the amended complaint appendix at page 48, which is a December 15, 2020 letter. And also there's also appendix at 116, which is a October 19, 2020 letter. That's where Linda Racy, who's in HR, talks about what that language means. And that language in the summary isn't pointing back to the plan document. It's pointing to external benefit policies that you have for like health insurance, where if you have Blue Cross there, Blue Cross has this giant policy that this summary of benefits is a summary for that. So we can't change that contract we have with Blue Cross. And that's what that is referring to.
Oh, okay.
I think the only clear way you can read the contracts together is that plaintiff is, not entitled to receive his normal retirement beginning at age 60 because he didn't meet those requirements for normal retirement that are set forth in section 1-18 before he separated his employment. Specifically, while he had the 20 years of service, he was not age 60 at that time. And the notion that for somehow he can fit into that section 118 as a deferred vested retiree would be inconsistent with both his admission that he is a deferred vested retiree and completely nullify what it means to be a deferred vested retiree. As I mentioned, I don't believe there's any kind of conflicting terms between these two documents because there's a silence. I don't think there's a reason that you need to get into those interpretive kind of pointing back and forth, but I think I just explained why how it gets resolved at this point.
Your point is if there's a conflict, you have to look at, then it gets confusing because each agreement points to the other. But your point is there is no conflict because it's silence.
Correct. There is, yeah. You're correct, Judge Cameron. There is no conflict there. And plaintiff and Mr. Galati even kind of admitted that during the claim and appeal process when, which is, I believe, at Appendix 39, he talks about the defined benefit plan is altogether silent on such qualification on the age requirement.
But wait, I just thought you just told us that with regard to the summary, when it talks about the conflict provision and which document rules of the day, you were telling us that in the summary, that's not referencing the defined benefit plan document. It's referencing the other agreements like the health insurance or the disability insurance. And so the health insurance or the disability insurance language would control the day as opposed to the summary. I thought that's what you said.
Yes, somewhat. To be a little bit clearer, that language that you were asking about is in I think the introduction to the summary document.
Page 4 and 5.
Yeah. So that I don't think what I was explaining was that doesn't apply here because that conflict language just refers to external insurance documents. But taking it a step backward, as Judge Cameron just mentioned, we don't believe there's a conflict at all because you have one document that says when coverage begins for deferred vested retirees that are in coverage group number 5A, and one document that doesn't. So there's not. I don't think you have to even look to the conflict language, which hopefully makes life easier because there is.
So that brings up my next question, which is in the defined plan benefit document, it makes reference to coverage groups. Which document gives us the information we need to figure out which coverage group an individual is in?
that's in the record of just an admission that I don't think there's any dispute that he falls within coverage.
No,
group
I
number
want to know
5A.
which document tells me if I'm an employee and I want to figure out which coverage group do I fall in, what document do I look at?
I believe that's got to be in the summary, Your Honor.
In the summary, okay,
Yeah,
that's what I
there's-
thought.
Because what you have is two documents, one that is a broader document and one that gets more specific. So kind of that's another kind of that rule of you got to look at the more specific because there's no conflict there. One is general. We're going to talk about deferred vested. The plan's been around for a long time. Things change over time. That summary provides the details. And that's what the details the Retirement Commission looks at. That's what it's always looked at. That's what it looked at here. And that's why Mr. Galati's not entitled to start the benefits at age 60. If court doesn't have any additional questions, I'll defer to Mr. App.
I don't see any. Thank you.
Thank you.
Oh, thank you.
Good morning. Thank you for the opportunity today. And I want to address some other arguments and positions other than the ones that you just heard, though I'm certainly, of course, happy to answer any questions the court has on those as well. I think from the Retirement Commission's point of view, one of the big issues that we had at the lower court is that the lower court did not apply the correct standard of review for reviewing Retirement Commission decisions. There's no debate, and there has not been at the briefing at the circuit court or at the Court of Appeals, that the proper standard of review to review the commission decisions is the material substantial evidence. And you have that standard in the Van Zandt case, the McBride case, the Black versus Department of Social Services cases cited in our brief. Quote, it does not matter that the contrary position is supported by more evidence, that is, which way the evidence preponderates, but only whether the position adopted by the agency is supported by the evidence from which legitimate and supportable inferences were drawn. That's from McBride. Van Zandt, if there's sufficient evidence, the circuit court may not substitute its judgment for that of the agency, even if the court might have reached a different result. Here we have no debate from Mr. Gulati that that is the appropriate standard, or that at the Court of Appeals, we've argued that standard was not applied by the circuit court. And that's undisputed. There was no response in the brief to those arguments, which I believe under Michigan case law, Prince versus McDonald, that a party's failure to respond and brief merits of an allegation result in the issue being deemed abandoned. So I believe right there, Your Honors, we have reversible error. The court did not apply the correct standard. If the circuit court had applied the correct standard, we have on the record statements by the court specifically that, I'm sorry, I just want to get the quote for you, Your Honors. The trial court was, quote, convinced that the Retirement Commission and the airport's interpretation of the documents was correct at one point. Judge Hegarty put that on the record. If he was convinced that our arguments were correct, that should have ended the review, the discussion right there.
So what's our standard of review?
I believe your standard of review would be de novo for this type of case, Your Honor. I think, again, that the lower court committed reversible error by not applying correct standard of review and ruling and replacing his judgment, even though he conceded that this position was supported by material substantial evidence, if he was convinced by it for at least a time. Moving on, Your Honor, I think if there is ambiguity, and I think, frankly, a lot of the questions that have come up today were questions that the commission had as well, and said, wait a second, did these documents, is this the, forgive my millennial meme reference, the Spider-Man pointing at one another? Is that what this is? And they wanted to get some clarification. So that's why they requested the letter that counsel referenced from Ms. Racy from the Airport Authority explaining what that language means. I also think, as we discussed the past practice, you can see that in the actuarial reports that we included, and that going back many years, every year when the actuary calculates the liabilities of the retirement system, she has a lot of assumptions that get baked in, right? She assumes what the assumed rate of return is going to be, what mortality tables, when people are going to die, et cetera. When calculating the liabilities of the Airport Authority, the actuary assumes, and it's clear in every one of those reports, that deferred vested individuals like Mr. Galati will retire and commence their benefit at age 65.
But what weight should we be giving an actuarial determination? Is that what you're asking us to do? It certainly shows that the plan retirement system is relying on that information, but how does that help us with the legal question?
Yes, Your Honor, it does. That is what I'm trying to show, that that is a consistent established past practice. And if you are looking beyond the four corners of the agreement at extrinsic evidence, as the trial court did and acknowledged was an important thing to do here, I believe, quote, to help express the intent of the parties entering into a contract past practice to help guide perhaps primarily trial court judges in navigating the dangerous shoals of retirement plans. The trial court said we should look beyond it and look at what the past practice was, and the actuarial reports established that that was the past practice, as well as an affidavit from the deputy director saying they're not aware that anyone has similarly situated to Mr. Galati has been able, as a vested deferred, to commence receipt of benefits prior to age 65. So I think that's how the relevance of that, they help with the affidavit demonstrate that. Final point I would just like to make is it seems very much like when you read the transcript that the trial court based its decision on equitable grounds that were not raised, that were not alleged by Mr. Galati. It was, oh, well, he may have relied on this. There's no claim to that. If you go in there, there's actually a very specific hypothetical that the trial court asked counsel for the airport authority and myself was, well, what if someone had 20 years of service and they were age 59 and 364 days old and they retired? Would they have to wait till age 65 or could they commence their benefit right away? And we had the answer. They'd have to wait. They would be a vested deferred, wait till age 65. That's the plan provisions. That has always been how the retirement system has provided benefits and interpreted the plan documents. I'm sorry, I mean, clearly didn't like that answer, but that's how we have to interpret it. That's the same way if you start taking money out of your retirement account before you're 59 and a half, the IRS isn't going to care how many days before, you've turned the age, they're going to ding you with a 10% penalty. That's unfortunately how we have to administer these documents. So again, I want to again focus on the standard of review that really has been conceded should have been the material substantial evidence test, and that was not the standard applied by the circuit court. So that alone is reversible error, and we ask that this court will accordingly. And I would like to reserve some time for rebuttal. I forgot to say that.
One question, is this an ERISA plan?
No, Your
No.
Honor, this is a governmental pension plan, which is specifically exempt from ERISA.
Got it. Under federal law, right?
Yes, Your Honor, there's cases cited in brief that we've done on that.
Thank you.
Thank you.
Good morning, judges. My name is Jack Schultz. I represent plaintiff appellee Aaron Galati, who is in the courtroom with us today.
Thank you.
There are a number of issues at play here. I think the crux of this case is whether Mr. Galati was entitled to receive his pension upon attainment of age 60, notwithstanding that his employment terminated at age 57. So I want to get to that, but I would like to address the comments that were made by Mr. Abb and Mr. Schwartz. First, our claim is not one of equity. We did not argue equity. And the judge did not make a rule. The lower court did not make a ruling based on equity. The judge stated that he believed that the correct result in this case was based on Mr. Galati's interpretation and reliance on the plan, not detrimental reliance. We didn't argue that. And that's not what Judge Haggerty said. This is not an equity case. The issue of whether the summary of benefits, I get confused. SPD would be referenced in a federal plan. The summary of benefits and the plan, the so-called conflict. I want to read to you items that I've made in my notes regarding that. Page 4 of the introduction to the benefit plan. Quote, details including eligibility requirements for these programs may be found in the plan document. Should the information in this summary of benefits conflict with the plan document, information in the plan document will take precedence. Well, it can't be referring to itself. The summary can't be referring to itself as the plan. It's referring to the plan itself. Page 35 of the summary. This document is meant to be a summary of benefits only. Employees should consult with the respective policy or plan for specific coverage and eligibility requirements. The benefit plan, the summary is not the benefit plan. Our position has been that the defined benefit pension plan is the dispositive plan.
Okay, so let's talk about that for a second. In the defined plan benefit document, it specifically references in multiple areas coverage groups. So which document describes what the coverage groups are? It's not in the defined plan benefit document. So where is it?
Yeah, I agree with Messrs. Schwartz and Ab that I don't see it in any of the documents.
No, he
It's
said
been
it was
a
in
se-
the, he said it was in the
I
summary.
don't see it in the summary.
Well, it
Where-
specifically
where's it?
references coverages in the summary, so.
Well, it's been assumed that he meets the coverage group. That's been assumed by both parties, that he's in this particular member group.
Based on what document? What document lays out who's in that coverage group?
I don't know.
You don't know?
I don't know.
Okay, so you can't dispute the fact that the summary contains documents about that coverage group.
I'm not ready to go that far. I'd want to take a look at the summary.
Okay, fair enough.
I don't know. And the reason I don't is that it's never arisen as an issue in this case. Mr. Glady has been a member of the plan, which is references Plan 5A, and both sides have looked at.
So you agree he's in that coverage group? You just don't know
Yes.
which document actually
Correct.
established that fact?
Correct.
Okay.
Yes, correct. So, what I want to first address, what's our position? Why are we arguing he's entitled to benefits pursuant to the defined benefit plan at the time he attained age 60 and had 20 years of service? And the appellants are arguing the plan doesn't control, the benefits plan control. Well, what is the benefits plan? I'll start with the benefits plan first. The benefits plan says that
We talk about the summary?
the summary,
Okay.
the summary says that, I'm not quoting the exact language, but it says that if you're a vested deferred member with 8 years of service, you will begin your pension at age 65. Boom. That's what I believe that they are relying on. That particular provision, and it swallows up all of the other provisions in the plan, which grants benefits at age 55 with 25 years of service, age 60 with 20 years of service. How are those people getting paid?
When you say swallows up, what do you mean?
Well, because if you have, let's say there's a hypothetical employee, I'm not going to use the extreme example that Judge Hagerty used. Take an employee whose employment terminated at age 62, 20 years of service. I think appellants would agree that person is entitled to their pension benefit. That person ceased employment at age 62. If you go to the summary, you don't get paid until you're 65.
Why?
Because that's what, well, that doesn't make any sense. It's irrational, but that is what the summary says.
If I'm looking at I think I'm looking at the summary here. Hold on. Because it says that if you are 60 when you
I'm not.
retire. I'm sure I'm looking at the right document here. Looking at Exhibit B, the plan. So I need to be looking at the summary. Okay.
I'm looking at page 21 of the summary.
Okay.
Deferred retirement. And quite frankly, this is what Mr. Galati and myself have been told since this case began. Because he had 8 years of service, he was a deferred vested member, and he's not entitled to benefits until attainment of age 65. I'm going to quote from the summary on page 21.
deferred retirement. Upon completion of 8 years of credited service, an employee will be eligible to retire, but payment of retirement benefits will begin at age 65, regardless of whether the employee retired prior to age 65. Well, doesn't that include those who would be otherwise eligible? My hypothetical, age 60, those who clearly and were paid. Why were those, where's the authority to pay those people who were clearly entitled upon meeting, again, whether it's the age 55 with 25 years of service or the age 60 with 20 years of service? What's the authority for those people being paid if the plan is silent? And they're saying,
I think your biggest problem here is section 19A3. Because that section says the member or vested deferred member meets the requirements for normal retirement prior to the selected date of retirement, a service and or age requirement for normal retirement eligibility. And then it says specified in the member's coverage group. Well, it doesn't say anything else in the actual plan itself about how you define coverage groups. So we know based on that language, there has to be some other document we look to that specifies the member's coverage group. You can't give us a document to refer to because you don't know where it is. Hold on, opposing counsel has indicated it's in the summary. We've all read the summary. It is in there. Coverage group 5A is referenced in the summary. So how is the summary on that particular issue? And specifically, we're talking about 19A3. How is your client not bound by what the summary says applies to coverage group 5A?
19A3. A member or vested deferred member may retire normally upon completion of the following requirements. Look at 3. The member or vested deferred member. Vested deferred member means you can't be an employee and a vested deferred member at the same time.
But look at the last clause. It says,
okay.
It says specified in the member's coverage group. So we know that means what's the member's, what is the member's coverage group? Doesn't say in this document, which means there has to be some other document that gives us that info, right? What's the other document? Your answer is, I don't know. Counsel's answer is, well, it's a summary, and we've seen the summary, and it specifically does describe coverage
Well,
group
does that-
5A.
That would deny all the benefits that flow from 19, 118B3 and 119. Those provisions have to mean something. 19, so the member vested deferred member meets the requirements for normal retirement prior to the selected date of retirement, a service and or age requirement for normal retirement eligibility specified in the member's coverage group.
Right. What's the
Okay.
member's coverage group? 5A, right?
5A.
There you
Okay,
go.
let's take 5A. But if I go to section 19, normal, where it defines normal retirement, it says 19A3, or did we just do that? 19A3, we just read that.
I do agree with you on one point, though, which is that this is all ridiculously confusing. It's very poorly written.
Well, that also goes back to the, whether or not there was, you know,
Ambiguity.
it goes to the standard of review, really, doesn't it then? I mean, don't we have to just go back there if that's the case?
I want to finish this chain of provisions in the plan, which define normal retirement age of service, because that's defined in 19. So 118 says normal retirement age, normal retirement service and or age requirement for normal retirement is, and there are 4 categories: 30 years of service, 25 or more, age 55, 20 or more, age 60, 8 or more, age 65. So in part, though, some of those provisions overlap. You can meet, if you meet 1, 2, and 3, you meet 4. If you meet 3, which is what I'm saying Mr. Galati did, you also meet 4. And this issue of the basic contract principles that the specific takes precedence over the general, that provision would apply 20 or more years of service and age 60 or older. 119A states a vested deferred member may retire upon meeting the service and age requirements for normal retirement. Okay, same thing, specified by the member's coverage group. And quite frankly, this issue of the members coverage group has never been an issue, was not an issue in the lower court. It was not in dispute. So I think we all agree. It's about the agreement is it's confusing. Judge Hegarty had stated that he would have written some of the provisions better,
Yeah.
but
So would anybody.
yeah, but he didn't feel he was at liberty to do that, and the law doesn't permit words to be added to the agreement that aren't in the agreement. If you look at the four corners of the agreement, but for your argument that perhaps because we don't cite the members coverage group, if you look at the four corners, our position is Mr. Glotty's entitled to his benefit based on the four corners, based on the fact that he's a vested deferred member. He doesn't have to separate. There's nowhere in the plan that says you have to be employed at the time you make your claim for benefits. Otherwise, then the words vested deferred member would be irrelevant. They have to have some meaning. So it's confusing. It, I think, confounded the lower court. And as Judge Hegarty said he hemmed and hawed. And not Mr. Abbs said, well, Judge Hegarty said that there were times when I felt convinced that the reading is correct, referring to the reading advanced by the appellants. But if in the transcript, it says, ultimately, after much hemming and hawing, I can reach a decision, and I do reach a decision. There have been times when I felt convinced that the language must support Mr. Glotty's position because he's simply following the rules in the DBP that he was given. He then goes on to say, but he backtracks, well, maybe the airport's position is correct. And then he decided to make a determination. And I'm not absolutely clear on the basis for his decision. He ruled that Mr. Glotty's position, based on his reliance on the plan document, was correct. However, he also said that in getting to this result, he is ruling against the maker of the document, thus, to me, invoking the contra pro forentum rule that's spelled out in the Clapp case. I want to step back one second. I wanted to point out to the court that there is there's a typographical error in my brief. I referred to contra preferentum, misspelled, instead of contra proferentum. And there's also a reference to, this is also in my index. On page Roman numeral 7, there's a reference in the final paragraph to plan section 1.18 entitled normal retirement. It should read plan section 1.9 entitled normal retirement. So again, I'm not sure what Judge Hegarty's ruling was based on. Was it based on, I've examined, I believe, I'm using his, that he believed there's an ambiguity, and that rather than adopt a position that in the event of a unilateral agreement, that it would be, a decision would be against the maker of the document, which was which was the concurring opinion in Clapp, but not the majority opinion, which required the court to look at extrinsic evidence to determine what is the intent of this agreement.
But you agree with opposing counsel that our review is de novo, right?
I agree. So extrinsic evidence was presented in the lower court. It was available to Judge Hegarty. So we have to assume that he took that into account when he made his ruling and decided that that evidence does not rule the day, and that the words have meaning, and that's what he got back to. So with that, I'm going to stop and field any questions.
I don't see any. Thank you. All right, any rebuttal?
Just to take it in, I think, somewhat reverse order, the rule of construing against the drafter, I don't believe it applies here, but to the extent it ever does apply, and in the clap case, it applies, the court says it applies after, like, you apply all other rules, including the review of extrinsic evidence. So that's like kind of a last resort, which I don't think you get to here, and you can never get to with the deferential standard of review. Second, the example or hypothetical that was presented, it was suggesting that, you know, if you have someone who's 20 years, got 20 years of service and age 62, and somehow they won't get their benefit under the summary until they're age 65. Well, if you have 20 years of service and you're age 62, you fall within a normal retirement benefit under 1-18B3. That's not what, so it's, you don't even get to that paragraph that we've been focusing on page 21 of the summary. That person is a normal retirement, and that's actually higher up on that page 21, where it talks about the same thing, 20 years of credit service at age 60. Last point I'll briefly make is, I think Judge Hegarty's, you know, when he's going back and forth, he lands, and we cite this on page 5 of our brief, where he's making conclusions based off of, I know Mr. Galati's not asserting an equitable, you know, you should rule in favor of me because of equitable considerations, but that's what the Judge Hegarty's opinion, or, you know, reading from the bench reads as. I do therefore adopt plaintiff's interpretation in reliance upon. And that's what he says on page 22 of a transcript, which was on the appendix at page 624. So I think that was also improper and reversible error. With that, I'll defer to Mr. Any further questions the court may have, and if Mr. Rapp has anything additional.
I don't think so.
Thank you.
Thank you.
We asked the court to reverse. Thank you.
All right, thank you both very much. That matter is,
I want to eat up this time.
okay, that's fine. Yeah, go right ahead. Go ahead. No, that's fine. Thank you.
I will keep it very brief, understanding I am still going to make some of those points. I do want to rely again that I believe the lower court did not apply the correct standard of review. That again, that's not opposed. I believe that's reversible error right there.
Our review of the decision is de novo, but the trial court's review of the commission's determination is to be given considerable deference.
Yes, Your Honor. The material, as long as it's based on some reasonable, substantial evidence that anyone that you could draw, that you could reach the same conclusion, then it should be upheld. And the statements made on the record show that I think it's pretty clear Judge Hegarty went back and forth. He saw both sides, and that's why he decided to rule against the drafter, which I would also point out, again, I agree with the comments that that's inappropriate under the deferential standard of review. And also, the retirement system didn't draft these documents. We weren't the drafter. So that doesn't really apply to the retirement system at all. Again, he seemed to very clearly rely on equitable arguments, cite the same relied on. He also the judge talked about an unpublished opinion and said that involved, quote, certain reliance on certain representations. It was a big part in the transcript of what he was talking about, that seemed unfair for whatever reason. I also quickly wanted to cite, I believe Judge Wallace asked for cases about past practice. The Clapp opinion discussed, as well as Amalgamated Transit Union, both Michigan Supreme Court cases cited in our brief as well. And then just finally, there seems to certainly, if there's consensus about something in this room, it is certainly that the documents could be confusing. And I think that's all the more reason why the Retirement Commission that should be given deference to its expertise as to how it's interpreted this, not just in this case, but again, going back, looking at the extrinsic evidence, historic past practice of consistently always applying it this way. Happy to answer any other questions, but I appreciate the time.
think we're all set.
Thank you.
Thank you.
Thank you.
All right, that matter is submitted.
Have a good day.
Turning now to item number 20, in Ray Field Miners, item number 379588. All right, thank you very much. Because no one has checked in, that matter is submitted on the briefs. Turning now to consolidated cases for item number 21. Item numbers 376972 and 377027. In Ray Johnson Miners, no one is in, well, we have actually Mr. Marshall is endorsed.
Yeah, I don't see Mr. Moore.
Thank you very much. The matter will be submitted on the briefs. Turning to item number 22, which is consolidated cases 376739 and 376740. In Ray NL Pitts Minor, no one is endorsed, therefore submitted on the briefs. And then finally, item number 23, in Ray UC Minor, item number 379061, no one is endorsed, submitted on the briefs. Thank you all very much.